Welcome back to the Constitutional Clarion. This video is about the relationship between illegitimacy and the Crown. Now, of course, whether a child is born within or without wedlock these days is neither here nor there. The legal consequences of what was once described as illegitimacy have largely disappeared. But there's one important exception, and that is inheritance of the Crown of the United Kingdom and of the various realms, including Australia. So can an illegitimate child succeed to the throne? And what happens if someone does inherit the Crown, but is later shown to have been illegitimate? As a constitutional lawyer with an acknowledged expertise in constitutional matters concerning the Crown, I'm occasionally contacted by people who claim that they are the real monarch of the United Kingdom and Australia, and they want me as an expert to recognise their status and give them some kind of legitimacy. Now, the story they tell me is almost always the same. They always felt special and different from birth. There was a secret that was kept from them. There were whispers and sometimes mysterious benefactors. Finally, there is the big reveal that a relative was a servant in the royal household, or sometimes just a friend or an acquaintance of the monarch, and that the person involved is actually the firstborn child of the monarch, or indeed a lineal descendant of one from a previous monarch, often from centuries before. This, they say, makes them the real monarch now. Now, when I point out that illegitimate children, even if they are the firstborn child of a monarch, are excluded from the succession to the Crown, these people tend to get rather angry and say, well, they've never seen that in any of the statutes and it's not true. But it is true. Anyone with even a fleeting knowledge of British monarchical history would be aware of the many illegitimate children of monarchs who could not inherit the Crown. In Tudor times, this became even more complicated with the legal manoeuvres to declare Henry VIII's first two marriages invalid, making Mary and Elizabeth both illegitimate, and the later efforts involved in re-legitimising them. Succession to the throne of the United Kingdom is determined by a combination of common law and statute. The common law rules concerning succession to the throne are based on those concerning inheritance of real property. They include, amongst other things, a requirement of legitimacy. While statutes in the United Kingdom in 1926 and 1959 largely ended legal discrimination based on illegitimacy, they contained express exclusions in relation to succession to the Crown. So only the legitimate heirs of the monarch can succeed to the Crown. The Royal Marriages Act 1772 was enacted, amongst other reasons, to provide clarity as to legitimacy. It required the King's approval for the marriage of his children and their descendants, or otherwise the marriage would be invalid, leaving the children illegitimate and unable to succeed to the Crown. Hence, even though the then Prince of Wales, later George IV, went through a form of marriage with Mrs. Fitzherbert, any children of the marriage were illegitimate and therefore unable to inherit the throne. As George IV's only legitimate child died, the throne then passed to his brother, William IV, who had fathered 10 illegitimate children with a mistress. None of the children born to his lawful wife survived childhood. As his illegitimate children could not inherit the throne, it then passed to Queen Victoria, whose parents, the Duke and Duchess of Kent, were validly married. Even though Victoria was born within wedlock, there has been speculation about whether or not the Duke of Kent was her biological father. This was raised initially by two scientists who studied inherited diseases. They contended that a break in the royal line was suggested by the fact that Queen Victoria was a carrier of haemophilia, which affected some of her descendants, when there was no record of it afflicting the royal family before Victoria. They also noted that she did not seem to carry the disease porphyria, which had afflicted King George III. The author suggested that the odds of a spontaneous DNA mutation causing haemophilia were greatly outweighed by the odds of Victoria's mother taking a lover afflicted with haemophilia. Their use of probability statistics, however, was the subject of some criticism amongst academics. This theory of Queen Victoria's illegitimacy was also pursued by the historian A.N. Wilson in his book The Victorians. He pointed out that the Duke of Kent had had a mistress for 27 years with no resulting children, unlike his brothers who seemed to have produced lots of illegitimate children. He thought this might have suggested sterility and that by the time the Duke of Kent married Victoria's mother at the age of 51, he might not have been capable of producing an heir despite the enormous pressure on him to do so. Unsurprisingly, the media picked up on this theory in the mid-1990s with a number of articles querying whether Queen Victoria was illegitimate and what the consequences of that might be. Wilson later recanted on this theory, basing his revised view on the physical resemblance between George III and Victoria and relying instead upon haemophilia arising from a spontaneous mutation in the DNA. If it were true that Queen Victoria was not the biological daughter of the Duke of Kent, would this make any difference today to the status of King Charles III? The answer is no. If Victoria had been found to be illegitimate before acceding to the throne, then this would have resulted in the Duke of Cumberland, the next brother along, becoming king and a different line of succession following him. But this did not occur, and even if proof could now be found that Queen Victoria was not descended from King George III, it would not affect the status of King Charles III today. And this is for reasons based on both the common law and statute. There was a presumption at common law that the child of a woman who was legally married to a man was that man's child, unless evidence showed that he had not had access to his wife during the period of gestation or that he was sterile or impotent. Lack of access could be established if the husband was away at sea or in another country fighting a battle or otherwise just not there during the relevant period. Only if it was impossible for the husband to be the father of the child could the legal presumption in favour of legitimacy be defeated. For example, it's been argued that King Edward IV was illegitimate because his father was absent at the time that he was conceived, and that the crown should therefore have descended upon his younger brother so that it would in the end have been inherited by a fellow who is a farmer in Jerilderie in New South Wales, Australia. At least that's the claim that was made in a 2004 documentary called Britain's Real Monarch. But back to the law, there was also an evidentiary rule that neither the husband nor the wife could give evidence about the lack of access in order to bastardise the child. If such evidence were given, it had to be given by persons who were not parties to the marriage. The presumption of paternity and the evidentiary rule were intended to protect the welfare of the child even when he or she was a product of adultery, so that the child would be financially supported by the husband. Lord Mansfield said that it is, quote, a rule founded in decency, morality and policy that a husband and wife shall not be permitted to say after marriage that they had no connection and therefore that the offspring is spurious, unquote. Under the law, as it stood at the time Victoria was born, there was a legal presumption that the Duke of Kent was her father, and there does not appear to be any evidence that he did not have access to the Duchess of Kent during the period in which Victoria was conceived. Unless someone was standing to do so, could have proved in court that the Duke of Kent was sterile or impotent, then the presumption of paternity could not have been displaced. no one sought to do so. Hence, as a matter of law, Victoria was regarded as the legitimate daughter of the Duke. But perhaps more importantly, the UK Parliament recognised Victoria as Queen, as it has indeed recognised her successors as holding the office of King or Queen. In the United Kingdom, a monarch only reigns as long as he or she has the support of Parliament. This was established in 1688 when James II fled the country. Parliament conferred the crown on Mary and William of Orange and set out statutory rules for acceding to the throne in the Bill of Rights of 1688. Parliament also reset the line of succession to the throne by the Act of Settlement, 1700. It has since altered the succession by the enactment of His Majesty's Declaration of Abdication Act 1936 to provide for the abdication of King Edward VIII, and the Succession to the Crown Act in 2013, which changed the rules in relation to inheritance of the throne by removing the favouring of males over females and dealing with disqualification for marrying a Catholic. Ultimately, it is Parliament which, by law and acceptance of a monarch, determines who actually holds the office. This initially occurred through acceptance by the Houses of Parliament of Queen Victoria's role and powers in summoning and dissolution of Parliament and the giving of royal assent to bills. But more critically, from a legal point of view, it was also reflected in legislation, which could be regarded as overriding any common law requirements and impliedly amending any inconsistent earlier statute. There are many examples of legislative recognition of Victoria as Queen. They include 2 acts of the Westminster Parliament that established constitutions for its colonies: the British North America Act, 1867, which conferred a federal constitution on Canada, and the Commonwealth of Australia Constitution Act 1900, which provided for the establishment of the Commonwealth of Australia and set out its constitution. The British North America Act 1867 referred throughout to the Queen, including in Section 9 vesting the executive government and authority of and over Canada in the Queen. The 5th schedule to that Act identifies that Queen as Queen Victoria. And Section 2 provided that references to the Queen in that Act extended to her heirs and successors, Kings and Queens of the United Kingdom of Great Britain and Ireland. Similarly, the Commonwealth of Australia Constitution Act 1900 refers throughout to the Queen and says that such references shall extend to Her Majesty's heirs and successors in the sovereignty of the United Kingdom. The Queen is identified in the schedule as Her Majesty Queen Victoria. It was Queen Victoria who by proclamation actually established the Commonwealth of Australia. As King Charles III is Queen Victoria's heir and successor, then he holds office as King of the United Kingdom, and since the Crown became divisible under Australia's laws concerning succession to the throne, he is also King of Australia, as well as being King of his other realms. There are many other Acts of Parliament of the United Kingdom which refer directly or implicitly to the different succeeding monarchs recognising their status as sovereign. They include laws that authorise the conferral of royal styles and titles, all of which authorise the use of the title of King or Queen in relation to particular monarchs, and those concerning regency in the case of the death of the reigning monarch and the accession of an underage monarch. After King Charles's accession to the throne, members of both houses of the Westminster Parliament took oaths of allegiance to him, and both houses presented addresses pledging loyalty to him. So, for all those people out there who feel special and believe that they are the true king because they are descended from the illegitimate offspring of a monarch, I'm afraid that from a legal point of view, they are not so special and royal after all. Equally, for those who enjoy examining royal lines to identify disruptions due to a lack of access, this is not going to effectively cause a recount and the replacement of the current monarch. While these matters may make good plot lines for entertainment, they don't actually hold water when it comes down to the law. Thank you again for watching the Constitutional Clarion, and as always, I look forward to seeing you again next time. Goodbye.